Well, I'm going to try to use technology today. Who knows if it's going to work? It's probably going to time out on me every time I turn around. Great. Great to be back here. In 2002, Glenn organized a panel discussion up on the stage there with, apparently there were 5 different panelists. I was one of them. Our current Attorney General, J.B. Van Hollen, was another one of them. And we talked about the Patriot Act and the potential problems there might be with civil liberties in the Patriot Act. How many of you remember or think you might have been there, besides Glenn? Okay, so a few. Because this, even though I've been to Wausau many times since then, this church has certainly changed a lot. That whole addition, is new to me. And so this is great to see that the congregation is flourishing, and that's because when I talk to UUs around Wisconsin, which is fairly frequently, I always say that not every ACLU member is going to be a Unitarian Universalist, but every UU should be an ACLU member. And we're going to see at the end of today whether you agree with that or not. So this is the Essence of Democracy Forum, and Samantha was telling me about some of the programs you've had in the past, and they all sound great. I'm going to try to do one that strikes a balance between, big concepts, what is this essence of democracy, and things ripped from the front pages that are about what's happening with civil liberties nationally and in Wisconsin as I'm speaking. And when you think of civil liberties and democracy, at the largest level, you have to remember that democracy has got to be more than just majoritarian rule. And actually, civil liberties are to protect minorities, to protect all individuals and their families so that they're not abused by the government. One of the ways that people connect to the political world, to their government, is through voting. It's one thing that American citizens share, at least they're supposed to share in that. And today we'll look a little bit at what's been happening and why is it that voting can be so problematic these days for a lot of people in Wisconsin. But you have to recognize that over the arc of history, the arc of progress that we keep hearing about, there's been so much progress since the founding of our country. Since 1791, when the Bill of Rights was ratified, if you think about the development of constitutional law, it's really always bringing more people within the body politic, opening up participation. I think you can safely say that with the exception of prohibition, all the constitutional amendments really have tried to bring the government and people closer together, and there have been so many instances where the vote has been expanded by constitutional amendments. Laws and court rulings have done that too, but it's been a little more of a mixed record. Let's do a little quiz here, and I'm not going to ask people to stand, but I'm going to, and probably some of you have already taken this quiz, but let's do it anyway, and you can just raise your hands. Okay, in 1791, in order to vote, you had to be a white male adult over 21 who owned property and wasn't in prison. So how many of those people do we have here today? Okay, no, you don't count. You didn't get to vote then. You didn't get to vote in 1791? No? Okay. Okay. And, okay, so you can put your hands down. Okay, let's see who was added in, let's see, 1870, the 15th Amendment was adopted, which extended the vote to people regardless of their race, color, or former condition of servitude. Is there anybody who got to vote, or if they had been there in 1870 because of the 15th Amendment? In most local elections, yes. Yeah. Okay, how about, when was the right extended to women? That's going to help us. So it's 1920? 20, okay. So how are we doing there? Okay. Okay. How about for American Indians, when did they get to vote? It's like 1936 or something like that. How about 18-year-olds? 1971, something like that? So it's taken a long time, but then of course it's just in theory. You can vote, the Constitution says you can vote, but then there are all these laws that are out there that make it difficult for people to vote. You know, after the Reconstruction amendments, people could vote, but then what did we have? We had Jim Crow, and all of the advancement had taken place was wiped out. And it wasn't really until the modern civil rights movement, and particularly with the Voting Rights Act of 1965, that African Americans in the South particularly were able to exercise their right to vote and get registered. Hardly anybody was even registered before 1965. But then with the Voting Rights Act, things changed. But it's a never-ending struggle, and we're still fighting some of these issues today. And the fight is all about sort of a modern form of what we call at the ACLU voter suppression. You may have the constitutional right to vote. The laws may say that you're eligible to vote. You know, you've lived in Wisconsin for 28 days or whatever. But still, there's a real campaign that has deep historical roots around the country, particularly in the South, that tries to suppress the vote by throwing up barriers that make it difficult, if not next to impossible, for people to register and to exercise their rights as Americans. You know, if you go back far enough, particularly in the South, there were poll taxes. You had to pay in order to vote. And very often, or more often than not, I should say, it was African Americans who were particularly disadvantaged because of poll taxes. And it wasn't until the 24th Amendment was adopted, ratified in 1964, that the poll tax was eliminated. And around the same time, other things were eliminated that had been obstacles, barriers to vote, like literacy tests, grandfather tests, all kinds of things. So you would think, oh, we got rid of all that stuff. More and more people are voting, particularly in states like Wisconsin. We have very high rates of participation, so it must be like a golden age for voting. Well, maybe there was, you know, for a little while there in 2008 or something like that. But sure enough, people around the country, not just in the South, but all over, started thinking about ways to suppress the vote. And so we may not have poll taxes explicitly anymore, but now there are new things that are used to stifle participation. And Wisconsin, unfortunately, has been one of those states that's seen so many of these tactics introduced, and many of them adopted, several of them still under consideration. In 2011, there were about 30 state legislatures around the country that considered laws that would require you to get out your government-issued ID and present it at the polls, or even if you're voting, send a copy if you're voting absentee, so that you could vote. So there was a whole proliferation of photo ID laws, and Wisconsin adopted theirs in 2011. It was 2011 Wisconsin Act 23 that went into effect in February 2012, that spring primary. And other states have got the same thing going on. Wisconsin's not alone. I tend not to be conspiratorial, but you just wonder if there wasn't somebody coordinating the introduction of these photo ID laws all around the country. I don't know, but we've had certain people who should know that have confirmed that. Then there were other things about that time that came along, a new set of voter suppression tactics. For instance, let's get rid of early voting, and that had been very successful. I think it was 2008, where about 30% of the electorate in the general election voted early. And also people who tend to work on Tuesdays and have lots of obligations, and people that can't walk away from their job because they might get fired, even though that would be illegal. And very often this meant poor and people of color who were eligible to vote were voting early because, say, in Milwaukee, you know, they had hours extended into the evening, they had weekend early voting, and even registration, same-day registration when you were doing that. But in many places that's been cut back, so early voting, the time frame for that is shortened. As I said, there's same-day registration in lots of places. Well, some states have eliminated that. In other states, other tactics to suppress the vote and make it harder for people to register. There's been lots of activist groups out there that have been trying as third parties to register people, and they have campaigns to register people as special deputy registrars. Well, I have to admit that some of those campaigns had some problems, but still nothing that would warrant closing them down. But in several states, you know, that's been changed. So now it's harder to register, it's harder to vote early, and for a number of people, a lot of people, it turns out, you have to show a photo ID. And a lot of people, including even ACLU members and other audiences I talk to, say, what's the big problem? I have a photo ID. I am a conscientious citizen, and I register and I vote in every election. And I believe these folks, and I'm glad that they're proud of, you know, exercising their rights to be citizens. But I don't know if they really recognize that there are significant numbers of people where that's problematic. They don't have a photo ID that's acceptable because it's a limited number, and they don't have the time or money even to go out and get the documents they need in order to get a photo ID. So this won't be a big newsflash to this group, I don't think, but the ACLU in December of 2011 was one of the groups that filed a lawsuit challenging the Act 23, the photo ID law in Wisconsin. There were actually 4 lawsuits that were filed, and everybody knew they were going to be filed. You know, for years I would go up to the legislature and people would come up with this sort of idea, and I would tell them you can't do it. And I was even at one meeting that Jeff Stone, Republican from Greenfield, was chairing, and he says, oh yeah, we'll take that into consideration, but you know, it's like one ear out the other. So people knew that there were difficulties with the law that was under consideration here in Wisconsin. So nobody should have been surprised by the lawsuits that were filed. Sometimes I think that some legislators say, lawsuits, ACLU, you know, come on, bring it on. And what do they care? They're spending the taxpayers' money to defend the thing, and they, you know, it's good for their publicity, I guess, to be attacked by the ACLU. But we're not really attacking Jeff Stone or Governor Walker or anybody precisely. It's more like, hey, we're the group, the ACLU is the group that defends the Constitution, regardless of what party or administration is violating our rights. So we filed a lawsuit, and around the same time, the League of Women Voters filed a separate lawsuit in state court, which basically alleged that the state didn't have the authority to adopt photo ID. The NAACP Milwaukee branch and a group called Voces de la Frontera filed a lawsuit in state court that said, well, we know that African Americans, disabled folks, older folks, all are people who have difficulty getting photo IDs, and that case is still alive. It's in the Court of Appeals for Wisconsin, and ultimately will go to the Wisconsin State Supreme Court. And we don't know what the Wisconsin State Supreme Court is going to do with it, but given the composition of the court and the history of some of those folks, we don't have much confidence that they're going to strike down the photo ID law. So then there were two cases, one by a group called the Advancement Project and another case from the ACLU that were filed in federal court. And so we don't have to worry about the Wisconsin State Supreme Court. We're in federal court, and we filed that in December of 2011, and then in March we actually amended our complaint. And here's a copy of that complaint. And I'll hold it up towards like this, 3D complaints. And about 25 named plaintiffs who are also sort of representatives of citizens who are similarly situated, including Ruth Ellen Frank from Brokaw and Nancy Lee Wild from Rothschild, I think. But a number of different citizens who were really good citizens that wanted to vote, and many of them had been voting for years and years and years, but under this law they weren't going to be able to do it for a variety of reasons. Let me, if I can find it quickly here. Here's the list of accepted photo IDs under the law. So Wisconsin driver's license, Wisconsin state ID, military ID card, U.S. passport, certificate of naturalization, an unexpired receipt issued at the time of the application for a driver's license or state ID, an identification card issued by a federally recognized Indian tribe in Wisconsin, and an unexpired identification card issued by a Wisconsin university or college accredited in the state, and a student ID that has the signature of the student on it, along with the issuance date and some other things. There's problems with some of those types of photo IDs, like the university college ID. The legislature adopted that, knowing full well that hardly any current student IDs at the time met those criteria. The University of Wisconsin ID card did not meet that criteria. The legislature's Administrative Rule Committee told the Government Accountability Board that they'd have to do two things. One, they couldn't extend it to technical colleges, and two, they put in abeyance a solution that we had come up with where people could put stickers on student ID cards to fix that. So even with the list that they have, there are specific problems with some of them, but the big problems are that for a lot of people, particularly poor people and people of color, you either can't get one or you can't get one because you don't have the money to pay for it. And so on behalf of those people, we sued in federal court, and we're alleging that the photo ID law violates the Equal Protection Clause of the 14th Amendment, and it violates the 24th Amendment that prohibited poll taxes, and because we're in federal court and not state court, we allege that it violates Section 2, the sort of general enforcement section of the Voting Rights Act of 1965. So we went to court, sued the governor, sued the members of the Government Accountability Board, sued officials at the Department of Motor Vehicles, because a lot of what you had to do to get your ID was to go through DMV, and they were giving out misinformation and all kinds of problems. But the stories that you hear from people who can't get their photo IDs are some of the most compelling, and we're going to start hearing those Monday. Monday is actually the beginning of the trial that we have in federal court, where we're going to try to prove to the judge, Judge Edelman, that this law on its face and as it's been implemented violates the Constitution and the Voting Rights Act. So for instance, let me tell you a little bit about the trial. The lead lawyers on the trial are ACLU Wisconsin lawyers. Larry Dupuy, our legal director, and Karen Rotker, our senior staff attorney, and they're being helped by lawyers from the ACLU National Voting Rights Project. And so we've got some of the best talent in the state and some of the best talent in the country working on this, so we feel really good about this. And also, the ACLU of Wisconsin has really done its homework and done research, not just to speculate that it's difficult for people to get accepted photo ID, but actually gone out and done surveys and research to figure out who can't get photo IDs and see if there's racial disparities or people of color are disproportionately affected. And so we have researchers and expert witnesses. They're probably going to get on the stand on Tuesday. And, we spent tens of thousands of dollars on this. And the research clearly demonstrates that, yes, there is a problem. People of color, Hispanics, and African Americans have serious burdens when it comes to getting the photo ID that's acceptable. And so what might that be? Let's look at the case of Shirley Brown. Shirley's probably going to testify on Monday later in the day. And in the materials that have already been filed with the court, there's sort of a summary of her story. She is a 73-year-old African-American woman who lives in Milwaukee. She was born 73 years ago in Louisiana. And she wasn't born at the hospital, but there was a midwife. And so when she, tried to get an acceptable photo ID, like a state ID or something, she would have to present a birth certificate as, proof of identity. And she didn't have one. And she tried to get one from Louisiana, but they, after some rigmarole down there, they sent her, for who knows what reason, a copy of her younger sister's birth certificate. So there's just, it's just like, how much do people, it's a right to vote, and how much do people have to go dealing with bureaucracies and sorting their way through things, particularly when it's in another state, and end up paying money for these things. To get that certificate of naturalization that I mentioned is one of the 8 acceptable documents. Well, that's $600 to get one of those. So there's all kinds of problems. There's even problems with clerical errors where people have got the wrong name on the birth certificate, like Ruth Ellen, or we have a client, Eddie Holloway Jr., but his birth certificate says Edward Jr. Holiday. When he went to DMV, they said, no, this is no good. We can't accept it. It's got to be, exactly what's on your birth certificate or give you an ID, and that's not his name. So, but often in order to fix these problems, and sometimes they can be fixed, but you've got to spend a couple $100s to do that. So in effect, they're bringing back the poll tax in order to require these folks to vote. So all of this is going on. The trial starts tomorrow. It's probably going to go on for 2 weeks. The judge is highly unlikely to rule from the bench on the last day, but he's going to rule on this and decide whether or not he's going to enjoin or stay or stop the enforcement of this law. Now, of course, it's already been stayed or enjoined by the state court decision, but you know, the worry is that if the Wisconsin Supreme Court got a hold of it, that stay could go. So in effect, what the federal case that we're doing is like the backstop, so to protect against that. And it's going to be appealed, and there are other cases around the country in Pennsylvania, North Carolina, and other folks that have similar cases, and it's ultimately going to be at the U.S. Supreme Court. And we don't know what's going to happen there, but we have reason to worry a bit, because in the last term of the U.S. Supreme Court, this past term that ended in June, there was a very important case that they heard and decided called Shelby County, Alabama versus Holder. And Holder is Eric Holder, the Attorney General. Shelby County didn't want to have to get preclearance for changes to their voting rights laws, their system, their voting system, even though they had problems with violating voting rights in the past. But the Voting Rights Act of 1965 did a number of things. In Section 2, there's kind of the general enforcement that you can have, but there's also something that's worked very well for many years called preclearance. And that means that if you live in a state or a jurisdiction that's had a real history of violating voting rights, even if it was, you know, quite a while ago, you would have to get clearance from a court or from the Justice Department in order to make changes, so that you wouldn't put anything in that would deny people's rights to vote and, you know, then require them to come later and try to remedy it after they'd already lost their right to vote. So the U.S. Supreme Court in Shelby County, Alabama versus Holder, they didn't throw out preclearance exactly, but what they did was they did away with the coverage formula, the formula that was used to determine who gets preclearance and who doesn't. So they basically gutted the Section 5 preclearance. And wouldn't you know, within 48 hours of doing that, states were falling over themselves to introduce or reintroduce voting laws that would not have passed preclearance. In Texas, you know, they put in one of the most stringent anti-voting rights laws you can imagine within 48 hours. And people are just falling over themselves to do this. So that in and of itself kind of makes me think that maybe there was something to this preclearance. But so that's where the court is now, but they're going to get other voting rights cases, and we don't know what's going to happen. In the meantime, we're trying to fix the Voting Rights Act, and we're trying to work with Wisconsin Congressman Jim Sensenbrenner in order to get a fix for the Voting Rights Act. And the question now is, well, it will just be narrow to fixing that coverage formula, or will we do something more? And so there's a lot going on. I'm just going to mention a couple related things before we get to questions and answers, because I'm sure that's going to be more interesting, and I know that there's people out there that are going to know more about some of this stuff than I do. Why is voting so important? Why is, you know, because earlier I said that democracy is more than just majoritarian rule. It's not just 51% and you win, but it's really but voting and participation is a good reflection of the state of rights and civil liberties generally. Right now in the country, and particularly in Wisconsin, the divisiveness between the political parties, the partisanship, all that is going on, really, I think, turns off a lot of people. In fact, you can't blame people who say that they're not going to vote. You wish that they would, but given the way things are, there's a lot of people that are disturbed by this. But I think that the value of civil liberties is, ACLU truly is a nonpartisan organization. It sure seems like, 90% of our members are Democrats, and it sure seems like we're suing things that have been come up from the Wisconsin legislature and governor that are controlled by Republicans. But our real client is the Bill of Rights and constitutional rights and the values that they bring to individuals and their families here in Wisconsin and across the country. A good example of what can happen when bipartisanship occurs is happening right now in the Congress. And no, I'm not obviously talking about the shutdown or the budget or the debt ceiling or anything like that, but rather I'm talking about the reaction from people on both sides of the aisle to government abuse in the form of National Security Agency and CIA surveillance of ordinary Americans. When we had that debate, up on the stage there back in 2002, I remember going through and pointing out, well, this section of the Patriot Act is problematic. This section of the Patriot Act is problematic. And it was hard at the time, given sort of the public climate of opinion and all that, to get people to take our warnings very seriously. And actually, since then, some of the laws have even gotten worse. There's something called the Foreign Intelligence Surveillance Court, and there was a series of amendments in 2008, the last time that there were revelations of misdoing. Well, those amendments in 2008 actually made it worse, not better. But right now, there's a bill that's been introduced into the Congress. Congressman Sensenbrenner, once again, is a co-sponsor in the House. Senator Leahy is the sponsor in the Senate. It's called the USA Freedom Act, and the USA Freedom Act has ACLU strong support, and I encourage you to find out more about it. Go to our website, etc. Go to Congressman Sensenbrenner's website and read more about it, and then talk it up among your friends. And there's something else that you can do, and I was talking to a group of folks last night about this, and they were shocked, and you're going to be shocked too. One of the co-sponsors of the USA Freedom Act is Congressman Sean Duffy. So here's one of my asks. If you see the congressman down on 3rd Street or somewhere around town, go up and thank him for being a co-sponsor of the USA Freedom Act. Not all Wisconsin congressmen are co-sponsors, but hopefully more will sign on. But I think that really we have to think differently about how we handle these things, and the best news is that now it's got bipartisan interest, a new way to look at the way that we relate to our government. Because you can, we're going to secure the right to vote for every American, and they're going to be able to do that. But then you have to get the powers that be to act upon the real interests of the American people and not give way to fear and political partisanship. Well, you can have people help you fill out the ballot. It depends on what mechanism used, whether it's a touch screen or the traditional kind of voting machine, but you can have people help you fill out a ballot if you have a disability. They are. In fact, Congressman Sensenbrenner, not only is he a co-sponsor of the USA Freedom Act and a co-sponsor when it's introduced of a fix for the problems with the Voting Rights Act, but he's also very much interested in doing something to reduce over-criminalization or over-incarceration, and that's an issue that really has gotten a lot of traction from both sides of the political aisle. Right now, I could talk about that for the rest of the afternoon if you'd like. And in addition to that, the congressman is also very much interested in restrictions on the use of unmanned aerial vehicles or drones. And, you know, with all these things, his motivation is not the same as the motivation of the ACLU. There are reasons why he's doing what he's doing, and I can speculate on some of them. You know, drones, and this is purely speculation, I haven't asked him this, I suspect he's really interested in that because Rand Paul is out front of him on the issue of drones with that sort of libertarian faction of the party. When it comes to the Voting Rights Act, you know, I've got a picture somewhere. When the Voting Rights Act, Section 5, was extended in 2006, there's President George W. Bush signing it, and who do you think is standing right behind the president, sort of towering over him? It's Congressman Sensenbrenner. And he's always supported the Voting Rights Act, and it's because he realizes that it actually doesn't harm Republicans. He's figured out a way in the redistricting context so that it won't harm Republicans and actually can even advantage Republicans in some situations. NSA, I think he's rewriting history. When he was chairman of the Judiciary Committee at the time of 9/11, he was saying things like, wait, we have to slow this down, we have to have serious consideration of all these proposals in the Patriot Act. Well, he caved almost immediately. I think he was probably more interested in the prerogatives of his committee than some of the problems that we foresaw with the Patriot Act. But on the other hand, he wasn't the only other person that caved. The Democratic Senate leader, Senator Daschle, he caved. So what I'm saying is that we're not going to agree with these folks on the majority of issues, but at some point, conservatives and progressives and liberals come together when there's issues and mutual concern, and we need to take advantage of that and not just say, no, you know, I'm not talking to you because I don't agree with you on choice or something else. And I can talk to what we've had to do here in Wisconsin, and that's not been a terribly big issue here in Wisconsin, but we have been very active, not just, you know, suing over bad laws like the photo ID law, but participating with a nonpartisan coalition of folks working on voter protection. So throughout the course of the year, we're doing things like communicating to the GAB about their rules, and it could be even just tiny little things about signage. You know, what is there something that's confusing about signage? Then, as we get closer to election day, we sort of ramp it up, and once again with nonpartisan election protection groups, we work and do training for nonpartisan observers and training for people that want to let the voters know what they can do and what they can't do. I think it was in the last, must have been 2010, ACLU, working with the League of Conservation Voters, had a session here in Wausau where an attorney that we identified helped the League of Conservation Voters train their canvassers who in turn were going out and just talking to people at doors all around the state. So sometimes we do the training directly, but more often than not, we're trying to leverage what we're doing by training trainers, that sort of thing. And then, after the election is over, well, we look at what went right and what didn't. And you can go to the ACLU website for probably last time would be 2010, and we put out like a 50-page report that responded to complaints from all around the state and what was going right, what was going wrong. Maybe it's in Eau Claire where there's been problems with student voting. Maybe there's problems in other communities. But all of that, and what we hear from local district attorneys and the Attorney General's offices, that you're absolutely right. Minuscule numbers of instances where there's irregularities. Most often there's a problem that's caused by clerical error. Poll workers, we love them, they're great, but you know, they need to be well trained and they need to be adequately provisioned and get their breaks and all that. So a lot of the errors, and Kevin Kennedy, the head of the staff person at the Government Accountability Board, says that really you need to look for clerical error. And there's certainly not things that could be fixed by photo ID. You know, I don't want to speculate about what's going on in Waukesha County. It is interesting that if you look at different measures of racial disparity, that Waukesha County comes to the top. Earlier this year, for instance, the ACLU National put out a very interesting report about racial disparities in arrests for simple marijuana possession. And Wisconsin is one of the highest in the country when it comes to racial disparities. And Waukesha County, among major counties, if you will, has one of the highest levels of racial disparity. And what I think is going on is that because there are relatively few African Americans who live in Waukesha, because of the hyper-segregation in Metro Milwaukee. Milwaukee's on just about every measure, is the most segregated community in the country. Well, what I think is happening with these arrests in Waukesha is that there aren't that many African Americans who actually live in Waukesha, but if you go to Waukesha to shop or to work or whatever, you're going to get stopped. You know, it's called race out of place racial profiling, and you know that's a serious issue. Okay, Chet, have you got all afternoon? Okay, so I'll try to be concise. U.S. versus Windsor at the U.S. Supreme Court was an ACLU case. Edie's attorney, the private law firm, sort of went around and asked the LGBT advocacy groups, law firms, etc., for help. And when she got to the ACLU, we said, of course we'll help. And it became an ACLU case. And James Essex, the director of the LGBT project for ACLU, was co-counsel in the case. And at oral argument in the Supreme Court, he was sitting right at the counsel table. The case came down on June 26th, and Justice Kennedy delivered the opinion 5-4, and people were wondering what grounds was he going to rule on, and he could have just done it on some sort of federalism argument, but really he went beyond that, and he said it violated equal protection. So what he actually struck down, what the court struck down, was Section 3 of the Defense of Marriage Act, which is the federal recognition provision. And so that means that 1,100 plus benefits and obligations in federal law will now accrue to same-sex couples who are legally married in states that recognize those marriages. And at the time, let's see, there were 12 states plus the District of Columbia, but in another case that same day, the court allowed same-sex marriage to return to California, so there were 13, and now I think there's 14, and there's lawsuits all over. There's New Jersey, and that's going on. There's a lawsuit in ACLU lawsuits in Pennsylvania. We've got one along with Lambda Legal in Virginia. New Mexico, there's lawsuits going on. We're probably also going to change the map so that there'll be a critical mass of states that recognize same-sex marriages by the time it gets back to the U.S. Supreme Court, which will do in just a few years. There might even be referendums. Oregon is going to probably have a referendum, and of course there's still things in the legislature. I don't know what Illinois did this week. Illinois drives you crazy, but if they would ever get their act together, and I think that they could do it this coming week, we'd have same-sex marriage in Illinois given through the legislative route. So things are really moving along. And so June 26th, I was actually in Wausau that day, and it was real interesting. The decision came down, and and I was doing TV interviews. One of the stations from Wausau interviewed me. A station from Rhinelander came down and interviewed me. And I sort of had to take the position, this is a great victory. This is really good. Couples all across America are going to benefit, particularly in the states where marriage is currently recognized. But then you sort of get the question, hooray, yay, but what about Wisconsin? And it's kind of a downer because, of course, since 2006, we've had a constitutional amendment, Article 13, that prohibits not just same-sex marriages or any marriage in Wisconsin that's not between one man and one woman, but it also prohibits recognition of those marriages. So if somebody goes to Minnesota, or like some of my friends go to Iowa and get married, they're legally married. They're going to be, for many federal purposes, their marriage is going to be recognized, but not for state purposes in Wisconsin. So what we're doing and what ACLU is doing is to try to move that map so that one day the U.S. Supreme Court is going to strike down all these anti-marriage amendments in the 29 states or whatever have them. But in the meantime, we've actually been working very hard to try to get as much value out of the ACLU's victory in Windsor as possible. On August 9th, immediately after the decision came down, June 26th, ACLU, along with a whole host of LGBT groups, put out a series of legal guidance on what does this mean now. And Lambda and other groups were part of that. In that guidance, we suggested that perhaps there's going to be benefits that are going to accrue to people who live in domestic partner states or civil union states. Specifically, when it comes to Social Security. And so because of that, I was asked by the SAGE group at the Milwaukee LGBT Center to work with them on this and participate in a conference call with Carolyn Colvin, who's the acting commissioner of Social Security. So it's like the head of the Social Security Administration is having a conference call for LGBT activists, and about 30 of us were on the call on August 9th. And of course, administrators, even though the president had said, I'm directing my administration and the Attorney General to move to implement the decision, it takes time. And so during that conference call, the acting commissioner was able to say that they're working with the Justice Department to get clarification, but they urged people to go ahead and apply for Social Security benefits on the basis of their partner's record, if that's of advantage to them, or to apply for survivor benefits. So the commissioner was saying, we can't say anything definite, but go ahead and apply for benefits because we don't want you to lose anything. And what I anticipate is that the Social Security Administration is going to allow registered domestic partners in Wisconsin who have been together for at least a year to get Social Security benefits. And the way that would work is if you have a couple where there's a high income earner and somebody who's not such a high income earner, the lower income earner can apply for benefits on the record of the higher income earning. Straight couples do that all the time. It was really, you could see how it was put in place years and years ago to protect women who were not in the workplace. But this would apply to domestic partners in Wisconsin because Wisconsin law allows domestic partners to inherit property when there isn't a will. It's called intestate succession. So, we particularly tried to push that out, and there's a number of interesting things that are going on right now, so that even though the Windsor decision doesn't apply complete in, its most important aspects to Wisconsin, there's other things. One thing that I should mention, and I don't know if in Wausau anything can be done about this, but the Affordable Care Act has a number of significant items as they relate to LGBT, particularly transgendered individuals. And ask me more about this Tuesday, because Monday night I'm going to a meeting on it that's being put on by a group called the Congress for American Progress or whatever. So there's a lot going on. So even though the decision didn't get us everything we want, there's good reason to feel better. Okay, that's a very good question. I'm going to start by quoting Winston Churchill. In 1947, Churchill said that democracy is the worst form of government except for all other forms of government that have been tried from time to time. So it's definitely messy, and actually to an extent, the ACLU doesn't mind that mess. We don't mind the combativeness. We like to have a robust debate. We've got nothing against civic engagement. We really promote civic engagement, particularly with our youth programs. We have nothing against civil dialogue and discussion, but we do tend to notice that the people that are most in favor of civil dialogue and discussion are those who are in power and don't want to hear complaints. But it's certainly a messy kind of thing. Structurally, however, one of the worst things that has happened is the way that redistricting of legislative districts and congressional districts occurs. And I remember going back 3 or 4 years before, because you have to do redistricting after every census. That's part of the Constitution. So after the 2010 census, you've got to do redistricting for those legislative districts and congressional districts. I can remember going back 3 or 4 years talking with Mike McCabe and with Jay Heck and with all kinds of folks about, let's do something about redistricting and let's have a citizen commission and let's do this and let's do that. And I was suggesting some very specific things, like how do we count prisoners? Do we count prisoners at the prison or in the districts where they came from? Well, none of that really went much of anywhere, because after the 2010 elections, the Republicans obviously were in charge of the apparatus of government. Your query about the citizens voting for them, I don't know. I guess I would go back to the quote from Churchill, but also when it comes to the 2010 elections, if there are progressives and particularly Dems who are shaking their heads. How could this happen, particularly as it relates to the Assembly? When I think of what the Assembly leadership was doing at that time, my quote for that is, you know, the fault, dear Brutus, is not in our stars, but in ourselves. So I think people have to recognize that and just do better in the future. But the real problem with redistricting is that it's exacerbated the divisiveness and the extreme partisanship that I talked about before. Because what happens is districts are either safe Republican districts or they're safe Democrat districts, and the number of districts, and this has been for quite a while, you know, really aren't competitive. So that means that people go to the extremes. Look at the debate over the expansion of religious school vouchers statewide. You know, now Newman has them, Pacelli and Stevens Point has them, and there were some Republicans in the Senate, Senator Ellis, Senator Olson, Senator Schultz, and somebody else that I'm forgetting right now. With the exception of Senator Schultz, most of them backed off of their opposition or modified their opposition. And of course, now Senator Schultz is going to have a primary. They're going to run somebody who's, you know, in with the pro-school choice right-wing agenda against Senator Schultz. And when you get districts that are so non-competitive between the parties, then you get these primaries and you get, you know, extremism in government.